Okay, ready.
Members of the jury, in the consideration of every question submitted for determination and solution, and especially in a problem of the character of the one we have under consideration, we must always bear in mind that a proper determination and a decision depends upon a rigid adherence and undeviating fidelity to those cardinal principles of law laid down for the determination of rights and responsibilities. There is no room and no place in law for sentiment, for prejudice, or for bias, and especially in an action of the nature of the one which we have now under consideration. We must not, no matter how difficult the task may be, permit ourselves, because of any personal animus, because of any personal experience, because of anything outside of fact and law, to be governed, affected, or influenced in the determination of the question propounded. Despite the fact that you have given consideration and time to the consideration of the questions before you, regardless of the length of this trial, irrespective of the mass of testimony submitted to you, the question before you is an exceptionally simple one, and one when you do give due observance to the admonition I have given to you, which should be readily and easily resolved. This plaintiff charges all of these defendants individually and collectively to have conspired, to have illegally gotten together, to have concocted amongst themselves an improper and unjust and unwarranted scheme to take away from her that which by law was her absolute right. She asserts that these defendants conspired knowingly and willfully to destroy the affection of her husband for her, to have attempted and to have succeeded in alienating his affection. She therefore contends that since a right which the law gives her has been violated by these defendants, she is entitled to such damages as will be adjudicated by the rule fixed by law. As the presence of the defendants indicates at this trial, as the manner in which they have defended themselves against this aspersion indicates, they deny absolutely, unconditionally, and unqualifiedly each and every charge directed against them. Individually, they maintain that they never did anything, said anything, attempted anything, in any wise influenced anything, which could affect directly or indirectly the affections of the plaintiff's husband. Collectively, they maintain that there never was anything in concert between them, nothing ever arranged directly, actually, materially between them which tended to and which did in any wise procure the alienation of the affections of the plaintiff's husband. We are therefore confronted with a clear-cut, well-defined, easily understood proposition. There is no difference between these individuals which is not clearly apparent. Plaintiff charges directly the wrong of alienation of affections. The defendants, individually and collectively with equal vehemence, deny the charge. So, in consequence, we must consider and concern ourselves with testimony in the first instance to gather from that testimony the transactions during this period of time, to determine from that testimony what was said, what was done by these individuals. And then, when in the performance of the duty which the law imposes upon you, as the judges of the value of the testimony, you have elicited the facts of the case. You take the law, as I indicated to you, and you will apply it to those facts, and from such application you will be able to say whether or not the plaintiff is entitled to your consideration, or whether victory should perch upon the banners of these defendants. In order that this may be properly done, in order that the law may be served by the law, as the law must be served, we must consider and we must search for those principles of law which define under what conditions and circumstances alienation of affections is established, and by the application of these rules of law to the testimony given at this trial, whether or not alienation of affections in this particular instance has been established. In this, as in all instances, we must remember that the mere making of a charge proves nothing. The mere fact that an individual charges another with a wrong does not mean that the individual so charged must be presumed to have done a wrong. When a charge is made, the law places the responsibility upon the individual who makes that charge to establish that charge, and so when the plaintiff charges the defendants with alienation of affections, it is not necessary in the first instance to assume an attitude wherein a presumption of guilt against these defendants is had. But we must do that with a knowledge that the law requires the plaintiff to assume full responsibility of showing justification for that particular determination. And therefore, with much care and in a spirit of actual impartiality, we investigate the law in order to discover whether or not the plaintiff has assumed that responsibility of showing that these defendants individually and more particularly collectively have done things which amount to alienation of affections. We discover that the law gives us a very plain and easily understood definition of alienation of affections. It tells us that the individual is guilty of alienation of affections if that individual knowingly.
Too fast. It's way too fast.